We understand that it is a very crazy time of year right now, so certainly sympathetic to people having to be elsewhere. I meant to be about 3 other places as well, so certainly understand that. We're going to hold off on Senate Bill 170. We understand Senator Hill is over in Senate Rules, where I should be. So at this moment, we're going to recognize Representative Stration. He's going to be presenting Senate Bill 175. Sure, that's fine. I'll turn you both on.
Thank you, Madam Chair, members of the committee. I bring before you Senate Bill 175 as passed by the Senate. This is follow-up legislation to the groundbreaking criminal justice reform packages that we've seen in successive legislative sessions here in Georgia over the past few years. I have the honor of serving on the Criminal Justice Reform Council. Mr. Miller, who's seated here with me, is a co-chair of that council along with Justice Boggs. The objectives that are, I think, covered here, you'll see, are followed from the recommendations of that council. This is one of 3 bills that are produced as a result of the report and recommendations that were made. Just to get right into it, there are 2 primary parts of this bill that I think you'll see as you review it. First of all, part of the bill deals with parental accountability orders. The objective here is to encourage parental accountability and involvement in cases where a child is repeatedly found to be delinquent or is in need of services, and where such an order is, first of all, of course, as we always include, in the best interest of the child, and where there are circumstances where the child poses a public safety risk, that there's evidence of repeated pattern of behavior of the child, and enhanced parental involvement could work to address the problems. These conditions are reflected in lines 17 through 20 of the bill. You'll see the enhanced involvement and supervision in order to address public safety concerns. I just highlight as to one of the objectives of criminal justice reform is to also be smart on crime, address the underlying causes, but also to hold in the top priority to maintain public safety and to ensure that that is addressed. What this would authorize is for the judge to compel parental cooperation toward the plan of addressing the underlying needs of the juvenile, and the available sanctions to the court would include civil contempt. So this is not criminal contempt, but it would be a civil standard of contempt. All right. Second part of the bill deals with a situation that we've unfortunately seen in several jurisdictions, and I'm also familiar of media reports related to this. It deals with juveniles that are in our current juvenile court system who are found to be incompetent. There is a hard statutory deadline in place where that juvenile is to be released, I believe, 5 days after that determination is made. And the concern is that there might be circumstances where that juvenile will be a danger to society to be released. And so the bill seeks to address the issue. Of course, some of you might be familiar, as I am, with similar circumstances in the adult system, and we have a process and a procedure I'm happy to go into with you in the adult system, but this would be to implement certain procedure for those circumstances in juvenile court. This is a very small number of children that would potentially be impacted by this, but these particular cases I think are compelling and require some action, I'd submit, by the General Assembly. Just to kind of hit the lines, the operational language you'll see in section 2-2, and that includes line 111 to 114. This strike and additional language provides juvenile court judges and the Department of Behavioral Health and Developmental Disabilities the necessary flexibility for temporarily detaining children who are found to be incompetent in an appropriate facility. So that is not necessarily a DJJ facility structured for simply confinement, but an appropriate facility. Also, moving on to lines 115 to 116, strike here is for clarity. It was confusing to judges as to whether they needed to meet the standard, which is a higher bar than that of an incompetency determination. Line 114 can be placed in the aforementioned department designated facility after a finding of mental incompetency, where the court can make the finding by clear and convincing evidence that all available less restrictive alternatives are not appropriate. So here again, highlighting the need due to public safety concerns. That's the only circumstance in which this would be utilized. Line 120, the child deemed to be incompetent is generally released unless detention is the least restrictive setting, as I mentioned, found by clear and convincing evidence, and that the detention is required to first reduce the likelihood of harm to self or others, demonstrate a pattern of theft or destruction of property that requires detention to resolve it, or detention is necessary to secure presence in court. The lines 133 to 140 speak as to if a child is unrestorably incompetent, can be detained until a comprehensive services plan is adopted. The child's incompetency may be remediated. It can only be the child may only be detained for the length of the time provided if adjudicated for the underlying offense. In other words, this is not going to exceed the underlying criminal offense for which the child was detained. I think many members of the committee here I know are familiar with the juvenile detention hearings and the procedural steps that are involved. The circumstances of these kinds of unique cases, I submit to you, need to be included in our juvenile code. Would ask for your favorable consideration.
Thank you. I appreciate that presentation. You have a couple of questions. 25, I believe that's Representative Rakestraw.
Thank you, Madam Chair. Okay, so it looks like in taking out the language in 111 through 116, and then in looking at the language 125 through 132, so we're taking away the treatment programs because, you know, there's a lot of kids that have things like oppositional defiant disorder where they may not get in legal trouble, but they're defiant and kind of hard to deal with, and it's hard to find places that can take them. As a matter of fact, even the treatment facilities are like, oh, well, we can't really do anything with that. So what would you do in those type of cases? Because putting an additional burden on the parents to have to meet all these hoops when they're already struggling just to get the kid to school every day and, you know, keeping them out of trouble. And are there any provisions in here for treatment for kids that are like that?
I think, first of all, we're talking about children who have been detained initially.
For something criminal.
That's right.
Okay.
And
so that could be like they said something in anger at school and somebody said, oh, they felt threatened.
No, they committed a crime. And
okay, so it would have to be like theft or
maybe more serious than that.
Okay.
And they commit a crime and they are then detained, and the objective here is to provide options for the best possible placement for that child in the interim.
But it looks like we're taking away treatment options when they may need treatment rather than jail.
So if I could, to clarify, the strikes there on 111 through 116, those treatment options exist elsewhere in code. This is solely in the context of the juvenile delinquency and adjudication where there is a mental incompetency issue. So to rephrase that, the psychiatric residential treatment facilities still exist for DBHDD. We're not removing that. In fact, the language we've added in saying a facility or program authorized or designated by DBHDD is intended to allow flexibility so that the subject matter experts with the department can help a juvenile court judge point in the right direction of the most appropriate place where, again, the child who is incompetent and also poses a significant public safety risk can be adequately treated. So certainly.
But then what about when those treatment programs don't exist? Because there's trouble finding treatment for those
Right.
types of kids.
And so that's what, parallel to this, we are currently in the process of pursuing, so this is a unique subset of children. When we reviewed the numbers from the last calendar year, we looked at about 10 children who could possibly fit the category based on offenses of crimes and the fact that they'd been determined incompetent. Now, a subset of that is going to be unrestorably incompetent. And a subset of that will have the ability to be remediated. Additionally, that 10 is sort of the broadest range based solely on the crime committed. So when you're looking at a public safety risk by clear and convincing evidence, it's likely going to require more than just that one crime. But that's the most we could do to kind of pinpoint what we were looking at. So parallel to this, we're working on a program that's going to be joint between DBHTD and DJJ, finding a place for these unique children, which may very well be a third-party provider, but something that does not reach the level of a DJJ hardware-secured facility, but something that's not the low bar of a purely community-oriented treatment facility. if
Or
that
an
makes sense.
outpatient, which
Correct.
doesn't work. Okay.
Right. That's
All
right.
right. Thank you.
Thank you. 18. Stacy? Oh, Representative Oliver.
Thank you. I believe Section 2.2 deals with a gap in the authority of the juvenile judge that was brought to Chairman Wendell Willard's attention and secondarily mine by Judge Willie Lovett and Judge Brad Boyd in relation to the inability to have a procedure to detain a perhaps dangerous young offender. We did not have a forensic unit to detain someone who could be dangerous, and that this procedure is necessary, and it assists behavioral health to create the treatment circumstances around that. Am I correct that that's where this is coming from?
Yes, that'd be correct.
Okay. May I ask another
Oh,
question?
sure.
Beginning on line 17, and forgive me if you may have covered this before I came in, this looks like something that would be helpful in the CHINS settings to create some accountability on parents. Is that an accurate general statement?
Chins or delinquency is where it's.
But particularly where CHINS, and I'm particularly focusing on truancy issue, which is the biggest red flag out there for. Is this something they can use to do something to make parents accountable for truancy? Is that part of your thinking on this?
Yes, there would be a plan that's put in place by the judge where the parents can be compelled to cooperate with the plan, with the ultimate potential sanction being civil contempt.
Thank you.
Okay. Thank you, Representative Oliver. Vice Chair Quick.
Thank you, Madam Chair, and gentlemen, thank you for your presentation. My question, and just want to make sure I understand, is related to Section 1-1 of the bill. And as I read this, this new provision would allow the juvenile court judge to exercise jurisdiction over a parent who's not a party to the proceeding. Is that what this does?
Parents, well, I would just submit to you that parents have a specific role in juvenile court, a recognized role. They're permitted to be in the courtroom, for instance. They're entitled to appointed counsel in certain cases, and so I'm not sure I would agree. I think your question as to whether they're a party, I would agree. Might agree in a strict legal interpretation as to standing, but they are given special consideration and special treatment in juvenile court proceedings. I don't know if you have
I believe Representative Oliver can shed some light on that issue.
Well, I have an opinion anyway. I think they already are parties, and I
And-
think the juvenile code reform clarified that children were parties, but parents had always been party, and maybe Jill knows more, I'm sure Jill knows more than I do.
But my question is with regard to the delinquency, and I was just going to move there I was going to try to piggyback on your distinction between the chins and the delinquency area. Certainly in the chins arena where the parents are given counsel, but this also applies to the delinquency proceeding, correct?
That's correct. Yes, ma'am.
And is that the same, I'm going to have to phone a friend and ask somebody more knowledgeable, is it the same scenario where a parent is provided right to counsel in a delinquency proceeding?
That's my recollection. I've actually seen that occur, and I think that's circumstances where a parent is, actually, it's these types of situations where a parent is being potentially going to be asked questions by the court, and the parent could potentially incriminate themselves, and the court believes, just sua sponte, makes a statement that the parent is entitled to the appointment of counsel, and the court be willing to do so. I mean, back to I'm not dodging your original question. I don't submit to you that a parent is a party to a juvenile court delinquency proceeding, but I do know that they are given special treatment and recognition both by the code and in practice in the courtroom.
Thank you.
Okay, thank you. Representative Raffensperger.
Thank you for your bill. I did have some questions, I guess, for a layman. In section 1.1 from 14 to 25, around actually line 21, you talk about getting an order restraining or otherwise controlling the conduct of such child's parent. Is there already some place in code where you can get a restraining order to control the actions of the child?
So Representative Abstration may be able to speak more directly to this, but I think in the actions of the child, that would be post-adjudication and the delinquency proceeding. And then also in the temporary proceeding too, normally there's allowances for preserving the court's jurisdiction or guaranteeing the presence of an individual.
Here's my question then. So you have a child that's out of control, say it's a teenager, and maybe this isn't the point of where you're going with this, but you know that they need drug and alcohol treatment. So they go in for drug and alcohol treatment, and they do that maybe inpatient for a while. But then after a while, then they go to, I guess, they go there during the day and then they come home during the night. What happens if they say, I don't want to go there next day, and now you're looking at a 200 to 240 pound, teenager, and mom is 120 pounds. So what remedy does she have then? And so, that's why I was just wondering why you wouldn't have I don't know if it's a restraining order, but an order where the court would compel the child to continue with the program.
Well,
Is that already covered somewhere in
Yes,
our?
sir. So that would be the sentence or in juvenile court, we call the disposition of the case. So that would be the court's order to the child with conditions. Typically, it includes probation, where the child has been ordered by the court to complete certain conditions. I think that the hypothetical you've raised would be up for judicial review in the courtroom. So the judge could make an assessment about whether, in fact, the parent has willfully refused to follow the conditions that the judge has placed on the child and or the parent, and whether or not that's actually occurring, or if the parent is doing everything he or she could do.
My concern more is that the parent does everything they want to do. They're not the ones with oppositional, defiant behavior. They're not the one that is hooked on drugs or alcohol. But it's really to compel the child then to continue with the program. And what you're telling me, that's already covered in our juvenile justice program. May I ask another question?
Sure.
Sure. Then sometimes when your child is out of control, parents are concerned about their financial liability, that they could be sued. So if your child is financially emancipated, then when you come over into page 2, you have on line 55, line 56, pay for the cost and expense of the child's counseling, treatment, and other services. If they've been emancipated, then you would not be held to this.
So to clarify, we're not changing current law in terms of the financial obligations for the costs and expenses there in 11, restitution in 12, and then judgments in 13. Those are already tools that are available in juvenile courts to compel the parent to pay those charges, but it could also be added in as a aspect of this sort of parental order. And to clarify what we're kind of seeking here, in the current juvenile code in 151129, there currently exist protective orders. And that's sort of telling an adult, could be a parent or guardian, be any other individual, to stay away from the child. The goal here is instead to provide an order that's bringing in a parent or guardian that can assist, in the development of the child. What the council found when we looked at the issue is, significant data concerning the lower risk of delinquency with increased parental involvement. So this is intended to kind of operate as a supplement to existing juvenile code.
Okay, one more.
For several months, I went out to Gwinnett Youth Detention, part of a ministry with Perimeter Church, and we minister to young boys and girls. And so I don't know if the parents ever really went out to see their children who were incarcerated. Could you compel them then to actually have, to perform visitation with their child? Would that be beyond the scope of this bill?
So if you look down to lines 59, 60, and 61, the court could take other actions that it finds reasonably related to the child's treatment, rehabilitation, or welfare and the safety of the public. So I suppose that could be a type of situation that a judge could include where it's appropriate.
Okay, thank you.
Thank you. Representative Rakestraw.
Thank you. So what do we do if there are not adequate treatment facilities to help these kids? Because I agree that there are cases where parents need more accountability, but there's also cases where kids need more accountability, and then special circumstances where we may be dealing with a juvenile that's 17 or 18, but they have the maturity of an 11-year-old, and they don't really, even though they're getting consequences, they don't really understand that this is long term and you're going to have a record, and sometimes that just doesn't play with those kids because of their emotional maturity level, because a lot of them are on drugs and trying to self-medicate what's driving the defiant behavior. But I'm hearing that there's not adequate treatment for these kids. So how do we help in that situation?
Yeah, if I may, kind of take a little bit of, indulgence from the chair. I think this bill really is seeking to kind of shore up some of those supportive services that are available to the juveniles in partnership with the parents, in partnership with the juvenile court judges, in partnership to make those children as whole as possible within the framework, and in dealing with some of those community-based services that are available to them, facilitating that process. So, I think this bill is a step in the right direction with that. So I think it's seeking to try to help that. So in other words, I think this will help services as opposed to take away services.
Yeah. Well, I guess I'm asking if the services aren't there, or if they need long-term treatment and they get the day treatments, but you can't get them there. And then parents are accountable for that. What provisions are in there for those type of situations? Because that happens often.
Sure.
With kids that have that type of diagnosis.
And so I think to separate these out into two separate contexts, one in the context of part one, where we're talking about the parental accountability order, and then two in the context of the mental incompetency determinations. First, as an overarching statement with respect to the services that are available through the Juvenile Justice Incentive Grant Program and through the Juvenile Detention to Alternatives Initiative, we have significantly increased capacity and alternatives to detention in family functional therapy programs, in substance abuse treatment for juveniles. So it's an active process in trying to recruit localities to offer these alternatives. As far as how it interplays with these two sections, to the extent the parent is being willfully obstructionist to the child's treatment, that's where part one comes into play. Where Part 2 comes into play is allowing DBHDD to have the ability to point to the most appropriate treatment for the child. What you see in the code before was limited to psychiatric residential treatment facilities and a few other facilities that DBHDD could issue. What we found is that in the incompetency where there's a public safety risk is a very unique situation, and something we're actively trying to pursue in that limited circumstance.
Okay, all right. Thank you. Representative Spencer.
In finishing your line of thought there, so this language in 113 and 114 gives a broader discretion, the way I read this, to seek other forms of mental health treatment or psychiatric treatment. That's how I read this.
That's correct.
All right, thank you.
All right. Thank you, Representative Spencer. Any other questions? Thank you. What is the will of the committee? There is a motion to pass from Representative Oliver and a second from Representative Quick. All those in favor, please signify by saying aye. Any opposed? Thank you, Representative Abstration. Motion carries.
Thank you, Madam Chair. Members of the committee.
Thank you, Representative Abstration. We will now call Senator Hunter Hill to present to us SB 17. We are working from LC 337027S. Senator Hill, welcome.
Thank you, Madam Chair. Well, I appreciate you and the members of the committee hearing this bill. Bring to you today Senate Bill 170. And I know you just said the LC, but just to verify, LC 337027S.
Yes, that's correct.
So I appreciate the opportunity here. This legislation stemmed from a desire to accomplish two things. Number one, to help retain our foster families and to help recruit future foster families. Specifically, this bill will help Georgia deploy an army of volunteers in support of foster families, helping those families foster better and longer. Further, many of those volunteers will, through their exposure to foster care, choose to become foster parents after playing a smaller role as a volunteer. Senate Bill 170 is about both recruitment and retention of foster families in an effort to provide ultimately more families to the nearly 14,000 foster children who have access to less than 4,000 foster homes. And specifically, there were three things we were attempting to address in the legislation, and I don't know if y'all have before you what passed the Senate, but it has significantly changed. And candidly, I'll just explain that process very quickly. We had, in our meetings, in our process, decided that we had the right solution, and so we put the solution in a Senate Bill 170 on the Senate side. But in working with DFACS, which they've been very helpful in helping us get to this point, we realized that we didn't have the perfect solution. So we went back to the drawing board, and what you have before you is now a process to create the solution. And so rather than put into code what was going to happen, we're putting into code a process by which we can ultimately come up with a solution. But for the purpose of the committee, I wanted you to understand what we're trying to address. We felt that there was a void in policy currently on the ground. And the existing policy called Reasonable and Prudent Parenting Standards did not adequately address the role of volunteers who come to a foster family from outside of the parent's existing network. And then there was a lack of uniform volunteer vetting, and this was challenging because if you were, for example, wanting to help out a family in Cobb County, and then you might go to Gwinnett, you might have a whole different set of standards. And we wanted to have a uniform system so that there's a lot of volunteers that want to come around and help these families. But if you've experienced in your own life when you want to volunteer for something, you're going to show up excited and motivated. But if it's your first time, if you come up against a multitude of barriers, you will likely quit. And so that's what we're trying to fix, is to make it a smoother process by which we can help our foster families. And the goal, of course, is to come around them in a way where they don't have a large network of organic help, large families, a lot of friends, because it's tough to be a foster parent, and that's the nature by which we bring the bill to you. So to create a standardization process, and then the third thing was there was a duplicative process. Once a volunteer is approved to serve, they can only serve around families approved in a specific agency where they were vetted. And so the end goal will be, someone that can have an opportunity. They choose to serve, they show up, and then if they've helped that family out enough, maybe they can go help another family. And so that's the purpose of it. And it was brought to me by boots on the ground representatives, folks Christian ministries that are already out there doing this, and they saw the problems and were helping us come up with a solution. But again, what we have before you is a way to come up with a final solution. I'm not presenting to the committee a solution that we have ready to hit the ground. That's what DFACS will come up with in this committee that we're creating. So I'll pause there, and I'm joined by Diane, who's been helping us come up with this process, and she can introduce herself and explain the process, and then I'm happy to answer any questions.
Okay. Good afternoon. My name is Diane Kelly, and I'm a private practice clinician as well as a child welfare consultant. I'm currently consulting with Promise 686. They have a foster parent support volunteer program called Live the Promise, and I'm assisting them with their implementation. Formerly, I was with the Division of Family and Children Services for about 14 years. And during that time, I worked on a number of key foster parent change initiatives, including development of the impact curriculum, establishing the procedures for the Foster Parent Bill of Rights, the youth rights and responsibilities, and then also the reasonable and prudent parent standards. So I have about 15 years of experience really looking at foster parents and why they become foster parents, what's their motivation, as well as how to recruit, train, support, and vet foster parents. So I have three reasons why I believe that this bill is good for the state. Number one, foster parents need support. All parenting is stressful, but foster parenting, with all of its demands and its unknowns, is probably one of the most stressful forms of service that one could do. Foster parents need tangible and concrete support in order to foster and to have any kind of longevity. Parenting stress is associated with a negative change in behavior as well as thinking towards children. So it's important that caregivers have tangible supports, like someone that can come over and bring a casserole or help with laundry or to help with babysitting, things that allow a caregiver time for self-care as well as breaks from parenting. And though the local efforts at the county level and also with our private agencies, they're going to vary, for the most part, our foster parents receive ongoing training. They receive 10 days of respite. They receive case manager contacts as the primary forms of support that they receive from the system. The Reasonable and Prudent Parenting Standards, which was passed around in 2015, it now affords foster parents more latitude in bringing in their natural support system to help them with some of these tangible, concrete supports such as babysitting. However, this bill will serve to support those who either don't have a natural support system or they need an augment to their natural support system. The bill will not impede or erode in any way the gains that have been made with the Reasonable and Prudent Parenting Standards. Second point is not everyone should be a foster parent, but those that are willing to play a role in supporting the work of the child welfare system, they should have a way to do so. Foster parenting is the deep end of helping abused and neglected children and families, and not everyone is equipped or desires to do so. DFACS gets on average about 20,000 calls to its foster and adoptive parent inquiry line, but only about 20% of those callers actually wind up fostering or adopting. So imagine if those callers also heard a message about volunteering. This volunteer system could grow very quickly and very rapidly just based on people who are already motivated enough to call the inquiry line. Third point is retention is as important as recruitment when you're talking about foster parent shortages, which Georgia as well as many other states are experiencing at this time. So instead of just looking at the need to recruit more, we also need to focus on retaining more. At the end of FY16, out of approximately 2,200 foster parents, DFACS foster parents, only 48% of them had 2 years or more of service. 29% of them had less than 1 year of service, and only about 27% had 5 years or more of service. It just makes sense that it costs less money to retain families rather than it does to go out, recruit, train, vet, and approve new families. And so veteran families are very valuable to the system. Because of their experience, they're going to be more capable of taking on the tougher cases, the sibling groups, the teenagers, the children and youth with special needs. Brand new foster parents are simply just not going to be equipped to deal with the more challenging cases. So we have to do a better job of keeping our veteran families, and a way to do this is by providing them with some more concrete and tangible supports that this bill will allow for. Finally, the community needs to support DFACS in addressing the problems that are facing our children and families, and we should not expect government to do all things. This is an opportunity for citizens to get involved, to make a difference, and this bill will help solve the problem of how to get involved, as well as a systemic process for screening, vetting, and how these families will be able to serve throughout the state. So this concludes my comments, and thank you for hearing my testimony.
Thank you so much. Senator Hill, anything else? You have some questions from the members of the committee. Representative Oliver.
I support this bill. I am aware that DFACS has done a number of different things to recruit and support, and there's been a specific appropriations on all of that, and particularly a $5 million appropriation year before last. I'd really like at some point, Madam Chair, to have some real information about what that money was spent for that was effective in terms of recruiting and recruiting volunteer efforts. Secondly, my church, Episcopal Diocese, has already a specific format involved in training and vetting volunteers, and that's essentially what you want to set up in some way, something like that.
May I respond?
Yes.
Not necessarily do we want to set up a process by which they're trained. It's really, some of those are already out there. The private sector, if you will, but they're all nonprofits, have filled that void. We were hoping that once they're vetted through that system, that they can have some sort of identification and go from county to county and have been approved and not have to keep getting reapproved.
Right. It might be true that the Episcopal Diocese program would fit for the Methodist.
Correct. Yeah, exactly.
My real question, though, is line 73 to 78 about immunity language. I just don't think I understand exactly what that means or how that may or may not be different from general immunity provisions in relation to other entities that come near or touch children under DFACS umbrella.
The intent was to protect child placing agencies who are licensed and monitored by residential child care licensing from fines and citations if one of their foster parents is supported by a volunteer and something happens.
Well, the liability for fines and citations is one part, but then the liability for negligence is another, and that's where I'm a little confused about what's the intent of this. I'm not, in general, and how does this create in any different way from any other state agencies' immunity status? I'm really asking pretty pointed legal questions that I don't know the answer to either, and I'm hoping you can explain it to me.
I mean, I would love for legal counsel to mention that, but clearly, when you look at on line 73, it says reasonable implementation of the policies. So there, gross negligence, you wouldn't be immune from that, or
Well, that's the question. That,
Yeah.
I mean, that's what you're, that's what I just
That's
need
what
to
your
know
concern is.
what
Yeah.
exactly, because for instance, in the, just I use this as an example, which may or may not be accurate, in the incidents of high-speed chases by law enforcement officer, law enforcement agency, if they are required to adopt a policy, and if they follow the policy, they're going to not be liable. But this is not what this says, so I'm confused.
Well, is
Oh.
legal counsel.
Okay, Jill, would you like to weigh in?
You know, I didn't draft this, so I'm not exactly
Yeah.
sure what the intention of the language is.
Yeah, where did it come from?
What's the spirit of it?
Who drafted it?
Betsy.
Oh, I'm sorry, it was done by the legislative council.
Right, yeah,
Yeah.
sorry,
Mhm.
I'm just saying personally, I wasn't involved in the,
Mhm.
you know, background of what was going on here. Obviously, the state, enjoys sovereign immunity, right? So
Mhm.
the department would have sovereign immunity. I don't specifically know if this is an intention to give
This
that-
creates immunity for private entities.
Right.
Under what standard? I just don't know.
Yeah.
Rob Fortson, I'm working with Roma 686 on this. The original version of the bill had a similar immunity provision, and the intent is for, in situations where a foster, what is ultimately going to happen with this is a uniform system for screening volunteers that DFACS will be involved with and confirm. If a foster parent uses one of those volunteers that has been screened, it provides immunity for that foster parent, so they're not disincentivized to use volunteers that have been screened through that system, who might be outside of their normal organic network.
So-
That's the intention.
Immunity for the foster parent, but not immunity for the private entity.
For a private child placement agency that is the overseer for that foster parent.
So a state-recruited foster care parent may not have immunity, but a foster care parent recruited by a private entity might? Is that what you just
No,
said?
The intention is it would apply equally in either instance. So again, the point is so that the foster parent is not in the private child placement agency, or not disincentivized to use these volunteers.
Anything else, Representative Oliver?
No, I remain confused, but thank you.
Okay. Representative Rakestraw.
Thank you. So my question is, so does this just relate to volunteers? Because I know a couple years ago, I, brought up some situations where I know we had a shortage of foster families. Do we still have a shortage? Because the hurdles that they have to go through to be a foster family, a lot of them just give up in the process. Like I have a friend, and she had to do things like get an inspection on her septic system and this big long list that was very costly for her to comply with, which I didn't really think was germane to her ability to care for the child and be a good foster parent. But have we looked at any of those requirements to streamline that so that we can get more people that are willing to foster? And does this apply to that, or is it just
No.
for volunteers?
It's just for volunteers. We didn't want to get into reducing or changing the standards by which somebody has to pass a home inspection, background check, and all that to be a foster parent. That may need looking at, but this does not get into that.
Representative Thomas?
Thank you so much, Chair. I have a question about lines 84 through 96, and it lists all the people that will be on the advisory committee. And I just have a problem because I don't see my name on there or Representative Thomas. No, but on a real note, have you considered maybe putting someone that was in the foster care system up past foster child? Because I'm pretty sure they would know exactly what they would want a volunteer to be like.
It
Yeah.
does say under X, one former dependent child or youth who spent at least 1 year in foster care.
And which one, where is this?
It's X on page 4.
Okay. Well, thank you for that.
So
okay.
you would be
I-
eligible.
Okay,
Representative
perfect. Thank you so much.
Excellent. Thank
And
you.
I have one more question.
Sure.
Can you tell me the difference between this kind of volunteer and a volunteer from CASA? What are they? Is this kind of the same thing, or are they performing different? What's the difference?
The chair will be happy to answer that, as I sit on the local CASA board and dealt extensively whenever I was a child advocate with foster families. This would basically allow for some supportive services for foster parents. Obviously, CASAs are appointed in our juvenile court and represent the children there. So that there would be two different arenas.
Okay, thank you so much, and thank you for this bill.
Representative Spencer?
I'm going back to line 73 through 78 on the civil liability question. I think it's important we flesh this out. There's nothing in that paragraph that talks about gross negligence or ordinary negligence. It doesn't talk about, if we go that route, do we put an evidentiary standard there? Are we talking about fees? Are we talking about if an entity has a duty of care to the child? We've got to, I think we need to address that in this paragraph, because that's a sticky legal issue.
Thank you, Representative Spencer. Representative Evans? Oh, okay. Representative Wilkerson?
Thank you, Madam Chair. You had mentioned DFACs had helped you with this. Are they going to speak on the bill at all?
I'm not sure. I hope so, but I don't know.
Okay, thank you.
That's your cue, Ms. Fielding. I will turn you're on at the podium. This is, for those members of the committee who may not be aware, this is Ashley Cooper. She is the legislative liaison for DFAC, so I'll recognize you at this point.
Thank you, Madam Chair. Yes, thank you for that question, Representative Wilkerson. Chairman Hill has worked very closely with the department on this bill in the last several weeks on coming to a consensus and determining what needs to be considered with regard to our provider network and policy with regard to criminal records checks, and we are supportive of the bill in its current form.
Thank you, Ms. Cooper. I appreciate that. Any other questions for the committee? I understand that the committee members have some questions with regards to the liability. And so at this point, what I'm going to do is I'm going to ask Senator Hill if he wouldn't mind to perhaps chat with Representative Oliver or maybe some of our legal experts here on the committee. Not you, Representative Quick, because you're going to be presenting the next bill. So stay where you are. But we have another bill, so we're going to just suspend this, and maybe we can come up with some kind of language. I don't know, because this bill has I know it's fluctuated and changed quite a bit as it's moved through the process. So I don't know if we just need to strike the language and just not address the issue, if that's really something that it might be antiquated at this point. So certainly that's something that Representative Evans, would you like to speak to that issue?
Yes, thank you, Madam Chair. That's exactly what I was going to suggest. To my knowledge, giving immunity to private entities who are paid for their work is unprecedented in the code, and so my suggestion would be that we just strike the language.
Yeah, I think given some of the permutations that the bill has been through, perhaps it might be antiquated at this point, but I will certainly let Senator Hill discuss that with some of his folks there, and we'll just suspend consideration right now on Senate Bill 170, and we will move on to Senate Bill 168. We're going to present, we just have a few structural changes that we're going to present, and then we'll come back to you. So thank you. At this time, I'm going to recognize Representative Quick. She is going to, Senator Miller presented Senate Bill 168 at our last meeting, and as we like to do in the House, we made Senate bills much better. And so we had some changes and additions to the bill to make it better, and so I will now recognize Representative Quick to speak to those changes.
Thank you, Madam Chair, and members of the committee. It is my privilege to present on behalf of Senator Miller this Senate Bill 168, which has been substantially shortened, let's just say that, in terms of not that we've taken that much out, but that there's some code sections that we weren't doing anything to, made it difficult to read through, and then I'll also highlight the changes. But don't get nervous as you look at the big original bill and then the new substitute to think that we're substantially changing it. That's not what is happening. So let me just walk through what both these sections are aimed toward. Section 1 deals with access to records of reports of child abuse, and Section 2 deals with the Central Child Abuse Registry. So as we walk through the provisions, keep in mind that they are in two different code sections doing two different things. But this 49.541 section is in subparagraph 2, adding an additional category of licensed adoption agencies. In subsection 5, cleaning up language that defines and describes CASA. On the next page, line 2 of again, we're working from LC 297554S, the substitute. This is a substantive change. This is the addition to the code with a new subparagraph 13, and that does a couple of things. One is it puts local and state law enforcement agencies in two different places in this structure, the statute structure, and I'll come back to that in just a minute. But it also specifically adds these additional agencies that shall have access to records, and provides that the access or release of those records may be provided electronically, and that is significant because the access to records being provided electronically applies only to these entities in subsection 3. And so, again, going back to the way the statute is constructed, this is the part of it that deals with who may be permitted access to records. There's a different part of the code section that deals with who shall be permitted access to records, and law enforcement is provided there in more detail in an investigatory purpose in different ways. So keep in mind, you're not looking at the entirety of the code. We weren't before and we aren't now, but this is just a simpler and more straightforward, I think, way to understand what's happening. With regard to the Central Child Abuse Registry piece of the bill, this is being broadened to include these entities that you see the added code language, so that all these types of investigations of potential child abuse that may be taking place are added. These entities already have access to records of reports in another aspect of the code. And then again, with regard to 1 and 6, that's what applies there. Number 7, subparagraph 7, that's the foster home placement background checks. And number 8, the adoption background checks. So, Madam Chair, these are folks that deal with the access to the Central Child Abuse Registry, and as I said, Section 1 deals with access to records, permissive access to records.
Yes, I appreciate that. Anyway, so does any members of the committee have any questions? What is the will of the committee in regards to Senate Bill 168 LC 297554S? There is a Representative Spencer makes a motion to pass. Do I hear a second? Multiple seconds. All those in favor of the gentleman's motion, please signify by saying aye. Any opposed? Thank you. Motion carries. I appreciate your assistance with that issue, Vice Chair Quick. Thank you. And we will briefly suspend, waiting on Senator Hill to return. right, thank you. We will start back with the Juvenile Justice Committee meeting. We now bring back before us Senate Bill 170. And Senator Hill, we had a question. There was a question with regards to the liability provision, and I believe Representative Evans is going to make an amendment, propose an amendment. I'm sorry, what is the will of the committee? There is a motion do pass from Representative Oliver. Do I hear a second? Okay. Representative Thomas wants to second the gentlelady's motion. And are there any amendments? I will recognize Representative Evans for an amendment.
Thank you, Madam Chair. I move that we strike lines 73 through 78 in keeping this code section consistent with how we generally handle immunity clauses and not providing immunity to paid private entities.
Okay, there is a motion and a second to strike in entirety lines 73 through 78. There is a second by Representative Quick. Any discussion from members of the committee? Representative Spencer.
Would it require the renumbering of the paragraphs in addition to the striking of those numbers, of those lines?
I will defer to Legislative Council, and it will. So there is a motion and a second. Senator Hill.
Madam Chair, I appreciate it, but as we all know, when we ask regular citizens to come down here, I know that I appreciate everybody, and it's likely going to pass, I hope, but there is a nice lady that took the time to come down here, and I was hoping she could just have a chance to speak.
Certainly. I do apologize. I know everybody's kind of rushed right now, and I do apologize. But, ma'am, if you would like to just, you can either sit at the table or speak from the podium, whichever you prefer.
Thank you. I appreciate it.
Yes, ma'am.
My name is Leslie Reese. I work for North Point Ministries. Some of you probably know us by our North Point campus. Some might know our senior pastor, Andy Stanley. We have a long-standing now foster care ministry, and I appreciate just a couple of moments that I can give you some context on why this has been so important to us. Because we're a big church with a big footprint, we actually interact with 15 different approving organizations, and as a result of that, we're getting the worst of what it is to try to create a sustainable ministry model. The fact that a volunteer that stepped up and was approved to support a family with Bethany Christian Services on their next iteration of support can't support a family with Giving Children a Chance or Faith Bridge Foster Care without beginning again to get their approvals is it's central to whether or not we can create sustainable, meaningful volunteer involvement. And the language that you just struck, I support striking at this moment, but what's going to have to happen when this bill goes into its action phase of building this system is it's going to have to be resolved, because right now child placing agencies do not want the exposure associated with volunteers that they didn't vet themselves. So the silos that exist are the preferred current state into the future, and that's just not going to work for the system to be able to become whole and healthy and thriving. So I just ask you guys to please say what you can to the people that you know who work in this space to be encouraging of this bill's actual outcome being achieved, because it's that important. We could probably recruit, I would say, at 4 times the pace that we do right now in all roles that we recruit, which include foster families, respite families, and these volunteer roles, if the system was not so cumbersome. So, thank you.
Okay, thank you, ma'am. I appreciate that. Representative Evans?
Not a question really, but just a clarifying comment. The placement agencies, when we talk about placement agency, I think we're talking about the department, and the department's going to have the same immunity that other governmental entities have. What we're talking about here are people that the department contracts with, which I think is different than the concern that was expressed, and I just wanted to make sure the committee picked up on that distinction.
Okay. Thank you, Representative Evans. Representative Wilkerson.
To the Representative Evans amendment, lines 13 through 17 talks about affected entities, If we're removing lines 73 through 78, do we need that language in there? Because I don't know if affected entities are addressed anywhere else in the bill.
I was trying to do a scan of that myself, and I was gonna assume that if it was gone, that should come out.
Okay, thank you.
But if the committee would indulge me for that, making that change if it's necessary.
The chair will so indulge. The wise, learned legislative counsel. So thank you for bringing that to our attention. I appreciate that. Representative Spencer?
I'll waive.
Representative Evans? Nope. Okay. All right. We now have a motion and a second to strike. I'm just going to kind of shore up because I've kind of lost the train. We are striking line 73 through 78 and or any other affected areas in the current legislation, SB 17 LC 337027S. There is a motion and a second for the amendment. All those in favor, please signify by saying aye. Any opposed? Okay, we are now back to the original motion of do pass as amended, Senate Bill 17 LC 337027S. All those in favor, please signify by saying aye. Any opposed? Thank you, members of the committee. We are adjourned.